appreciate everyone's attendance this evening. Thank you for taking your time out of your evening and your month to be here. There are 2 items on the agenda today for discussion. One is just House Bill 2614 and kind of an update of where we are in that process, and other legislation that is other legislative matters, I suppose. And then policy changes proposed by the agency to contracts that will come up for a vote during the commission meeting that's in person next week in Medford. So with that, are there any questions or any comments about that, or any input about the agenda before we get started? Okay. So update about House Bill 2614 and legislation.
So when you say the contracts that are coming up for a vote, this is
the policy changes that are coming up. The policy changes will come up for discussion and vote on Wednesday, not the contracts. But yes, it will be for this coming contract period. Okay.
Regarding the legislation, so yesterday afternoon, the public defense reform legislation passed out of the House Judiciary Committee with the -5 amendment. And that would have gone to the floor, and then it will go to Senate Judiciary, where it could be adopted or it could be amended. If it's amended, it would have to go back through the House before there was a floor vote. So that's kind of where we're at in the process on it, is that it has left House Judiciary and is on its way to Senate Judiciary.
And just so we're all on the same page about what the -5 amendments are, and also it passed out of House Judiciary unanimously. So everyone, obviously, that's what unanimous means, sorry. So 3 main provisions. One is it would extend consortia through 2033, right? 2033, and provide some parameters under which consortia would be allowed to contract and operate with the agency.
And those new parameters go into effect in January of 2026. So the timing on that is a bit awkward with the timing of our contract cycle. And we don't know from the consortia how many of them already have systems in place that would meet those criteria, or how many would need to develop new business practices or governance practices. So there's a pretty steep lift there on a short time frame, and it's in the middle of our contract cycle.
And those really are designed for governance and quality control and monitoring of consortia. The sunset, I suppose, of having the executive director be hired and fired by the governor would no longer be in effect. So the governor would have the authority to remove not just the executive director, but also commissioners for cause. Right now, the way the Senate Bill 337 reads is that it's for malfeasance. There's three provisions. Basically, you have to really mess up. and then it changes for cause, and also the executive director's for cause. Also creates a process for replacing the executive director that's appears on its face anyway to be a cooperative process with the commission, but ultimately the governor gets to make all those decisions. And then the third provision is really about budgeting and who the budget is presented to, rather than it being presented to the legislature directly by the commission. It goes through the executive branch process, which really, I mean, my understanding, I had a conversation with Lisa Taylor about that, because my sense was, and she confirmed, that really it's in practice wouldn't have much of a change. It's what we did this time. So it's just tightening it up to make it consistent with what already is happening with all the other executive branch agencies. And I feel like I'm
One
forgetting
more
something.
provision,
Yeah.
Jennifer, it removed the language in the statute that said that
Yes.
national and regional best practices for
Right.
public defenders, and then removed the language around pay commensurate with the work that they're doing. So the caseload and pay for contracted public defenders.
Right. And the legislature's impression is that they said, Representative Kropp said that he wasn't intending to change the standards. He just wanted it to be consistent with what our requirements are, which is constitutional representation. That he didn't want everyone to think that he was lowering the standards. So with that, it passed. There are some problems with the statute, obviously some substantive problems. And and the other thing that it did is it requires the commission to keep a list of all lawyers who are providing public defense services in the state. So there are some problems. One of the problems is the list of public defense lawyers should really be limited to lawyers who are providing public defense services for state cases rather than municipal court and federal cases. And two, that really should not be in the statute as a commission duty. It should be in the statute as an executive director agency duty, because that really is more of a clerical agency function rather than a commission function. So otherwise, I'm not sure how we would do that without having, I mean, we could delegate it, I suppose, except there's no statutory provision to allow us to delegate it. But in any event, so that's something that will need to be addressed on the Senate side. And both of those things. Also, what was missing that is we would like to get in there is the ability to have Plan B judges serve on the commission, because we've had difficulty filling the judicial position if we have a current, obviously, Judge Lipscomb, who is serving on the commission, but that position has been traditionally difficult to fill. So it would be easier if Plan B judges were allowed to also be eligible. And then from the commission standpoint, I mean, we have a fair number of people here. We can't take a vote, obviously. We can't do anything like that. But I would like to discuss what position we might talk about in a meeting to have a more formal, I don't know if we need to bring it up as an action item, but what the commission's position will be, if any, about the substantive changes about the removal of commissioners and the executive director for cause by the governor. That does touch our independence. The legislature doesn't seem to think that that's a problem. Not surprisingly, they believe that it strikes the right balance between independence and accountability, because it creates the comments were it creates a partnership with the commission to replace the executive director. Of course, it allows the governor to remove the executive director. And I'm sure there is a definition in some case somewhere about what for cause means. That's not my area of expertise, so I don't know, but I'm sure that's litigated. And I'm sure there's something about what for cause means, but it probably also is pretty broad. I mean, for cause could be, we don't like that you're not fixing this 4,000 people on the unrepresented list, for example. So I think we do need to discuss whether or not we're going to take a substantive position when it makes it over to the Senate side about that particular provision. And then we need to also address the timing issue regarding the consortia requirements, because that will pose a problem. I mean, even if they change the timing to January, or to ideally, that should be July 1st of 2029, right? That would be what you would want.
Well,
Director Kennedy?
2027, the.
Or 2027,
consortium
I'm
was set
4
to
years ahead,
sunset
yeah.
in 2027, so
Yeah.
if they use that same timeline, it would give people 2 years to get their governance structures in alignment with the legislation. And I don't know how long it will, I don't know how big that gap is, quite frankly. I mean, I would imagine that there are some consortium providers who are probably already pretty closely aligned, but I bet that there are others that are not, and I don't know the size of that gap. So it would be helpful to have information from the consortia organization about what their assessment is of how big of a lift that's going to be.
I was really thinking about it in terms of in line with the contract cycle. So,
In line with the contract cycle
Yeah.
would be July 1 of 2027.
okay, all right. Okay, so with that, comments, questions, discussion?
Well, you hit the nail on the head with the for cause. For instance, if a commissioner were to say that the governor's proposed budget was woefully inadequate to provide public defense, would that be cause for dismissal? And I believe it would be, if it's a expansive definition of cause. And I'm very disappointed. There's nothing apparently asking the courts to change the way that they are operating. That is all focused on the Public Defense Commission. Nothing is focused on changing the way the courts handle cases, the way the courts settle cases. None of that is in this bill at all. So nothing's going to really change.
I think that's accurate assessment. I think we are in the exact same place that we have been for decades. And the difference will be that the executive director can be removed and the commissioners can be removed and replaced. Maybe because somebody thinks that that will solve the problem. And it won't.
You know,
But
sorry.
no, go ahead.
I mean, yeah, sorry, before I mean, the chief was able to remove people, right? I mean, but it was the commission that had authority over the executive director, but of course you could get the
Rob,
commission to
we're having some trouble with your connection, I
remove the
think.
executive. What would be the alternative mechanism to removal if the governor didn't do it? Have we thought of that?
Well, the way the statute reads now is that the commission removes or after
Yeah.
2027. Okay, so in Senate Bill 337, there was a grand bargain that was struck, and the bargain prior to passage of that, it was the commission that hired and fired the executive director. For a temporary period of time of 2 years, that was supposed to be transferred to the governor, then revert back to the commission. The governor did not want that. She wanted if she was going to take on public defense as an agency, she wanted that authority all in. That wasn't in 337. There was just the 2 years, and then it was supposed to come back to us July 1st, 2027. And now that's being removed. And in addition to that, there's going to be the for cause Senate confirmation.
Yeah, so two
The-
things.
The
Sorry,
director, Rob, the director position is an executive level position, which means that the commission has the authority to remove for cause. I mean, it's not a management services position where you have to go through different processes to remove the director. It is a position that is an executive services position within the agency.
Yeah, so I guess what I would propose or think about or float here is let the governor remove commissioners, but not the executive director. That insulates the executive director from the decision making. And if it comes down to it, it could be she wants to
Rob?
remove with an alternative rather than just saying
We're having a really hard time
it's a
hearing you.
proposal is something we should think about.
Rob, we're having a really hard time hearing you. Maybe if you turn your video off and just use audio. So I think what he was saying is to have the executive director still removed and hired by the commission, but commissioners could be removed by the governor. And the way the statute reads now, commissioners can be removed by the governor, but only for malfeasance, absence, and something else. Susan.
Yeah, given the amount of time you need to put in to be an active commissioner, and combine that with a very ambiguous for cause standard and the political hot potato that indigent defense has become, I wonder how they're going to get competent people to be commissioners.
Well, I think,
We're already sort of
yeah, that's true.
walking on eggshells, trying to thread the needle between some level of independence and being tied to the governor's budget. I don't see how it's possible for people to want to spend their time doing something that's so tricky. So if they want competent people to be on this commission, I think that they have to have some more specific standards in place for what constitutes something bad enough to be dismissed. But the other part of this that concerns me, in addition to what you've already discussed, is taking away the national and regional best practices and pay commensurate with work language. And again, I'm not sure people have remembered their economics 101 education. I agree with Peter that only focusing on the supply side of all this and not paying any attention to the demand side of this is an imbalanced way to go about it. But if in fact we are getting to a place where public defenders are supposed to act like warm bodies with a law degree, which is essentially what the Sixth Amendment competent counsel standard amounts to, you're not going to get a lot of competent lawyers wanting to be public defenders. And so the supply side of this equation is going to get even worse than it is now. It will no longer, even for idealistic people who are pretty much the only people who want to be public defenders, it's not going to be sufficient.
I think that's the first step in a larger attempt to increase caseloads.
Well, of course it is, but they will not have enough lawyers who are willing to do that to service the number of people who are being brought into the system. And with the kind of economic disaster that may be impending in this country, there will be even more people being brought into the system. And so again, without paying any attention to the demand side, and yes, they haven't put anything in here to deal with judges. They also haven't done anything in here to deal with prosecutors. And I understand they don't have as much of a direct way to deal with prosecutors, but they have some ways to deal with them. And I think that this is just going to exacerbate the problem. And when that happens, they're setting it up to blame the executive director and the commission. So the whole thing, I think, is really fraught.
So there was a -7 set of amendments that came in late and came in yet today's Thursday, right? Sorry, the days are all blurring together for me. Tuesday, and did not make it out of committee and really didn't have much discussion at all yesterday. And that was a very lengthy bill that would set caseload standards. And it was introduced, it was introduced by Representative Wallen at the behest of, guess who, the Multnomah County District Attorney and the Washington County District Attorney. And it set, 300 weighted misdemeanors. I mean, it's very, very granular. And I was really kind of surprised that that there was any attempt to put anything like that in legislation, but it was dismissed out of hand. I would say that's a fair characterization. We understand there's an issue, but we're not even going to talk about this. But it would have been a good opportunity for the committee to discuss the supply side or demand side, whichever you want to look at. And there was no discussion about that.
Well, this is sort of and excuse me, I'll raise my hand again next time, but it seems to me that what they have now is a way to sneak all that in without saying in so many words that that's what they want. I really don't like it.
Well, so I think the next steps are, our next bite at the apple is judiciary, and one of our commission members is the chair of that committee. One of our commission members is the chair of that committee, and Senator Posanski is very understanding of the nuances and the difficulties of public defense. And so I think that, there's an opportunity there for us to have meaningful input. I do think that the main point of this bill is to ensure that consortia continue to operate. That's the main point of this. And then there were other things that were put in there to try to address other issues as well. But I think it's fair to say that the main point is to make sure that we've got some mechanism to continue to allow consortia to exist. And so we should, if we're going to weigh in, we should ensure that the things that are really important to us are the things that we're talking about, rather than, get rid of the whole thing, because there is going to be a bill. The question is, what is going to be in it? So what I'm hearing is it's important that from commissioners, it's important to talk about how we should leave the language that currently exists about national and regional best practices and caseload standards. And we should also discuss the independence piece for the executive director and the commissioners. Because I think you're right, Peter, if we're squarely in the executive branch under the subordinate authority of the governor, and the governor thinks we've been insubordinate in some way, that would probably be considered cause. So we need to make sure that that language keeps our independence. So with that,
Jennifer, do you want us to schedule the commissioners some time to talk about this outside of our regularly scheduled commission meeting? Or do you want to talk to me later about how to approach scheduling time for the commissioners to have this conversation with the whole group?
I think that makes sense. And with everyone except Representative Evans and Senator Posanski, I don't think they're appropriate for this discussion, just because they're in the legislature, and also it's, especially Senator Posanski, that would be very odd. But yes, I think that's appropriate. And then with that, let's move on to our very important next topic. Well, actually, before we do that, let me just ask, because I haven't checked with Mara, how many people are planning on being at the Medford meeting in person? Peter? Okay, and Rob and Susan. Tom, are you going to be there in person, or are you going to be remote? Tom may have stepped away for a minute.
I believe he
Okay.
told me he was going to be remote, and we have 5 people attending in person and at least 1 remote. Possibly 2.
Commissioner Harvey was the other in person, right?
Correct.
Do we have a quorum?
Yes, we would have a quorum of voting members.
And you have, so if you've only heard from 6 people total though?
Yes, there are some still outstanding that haven't responded.
Okay, can you just start calling people for me?
Sure.
All right, thank you. All right, well, if we can make that happen when we're, maybe next week, we can facilitate that either right before or right after the commission meeting, because we'll all be in one place, either by video or by in person. Okay, and with that, let's move on to discussing the agency proposed changes to contract terms.
Great, thank you. This is a decision that the commission's going to have to advance at the next commission meeting if we're going to be able to timely implement. So I just want you all to have that awareness as we move through our conversation today. Mara, can you pull up the slides? So I just have a couple of slides here. This is our introductory one. We're talking about the proposed contract modification. So you can see where we're at on the timeline. We are coming up. Our next thing is that April 16th commission meeting. And if you all are planning on approving these for the next contract cycle, that would need to happen at that April 16th meeting. The policies that you're considering would be the partial waiting for early withdrawal, the warrant removal, the co-counsel, second or subsequent attorneys, contract compliance, and reduction caseload for first-year lawyers and vacancy funding. Mara, can you put those down, the slides down? You all have previously received copies of the policies, so I didn't make slides with those copies. I figured you have access to them. Commissioner Harris had asked the agency to create a balance sheet where we looked at which of these policies would add MAC into the system and which ones would take away MAC, so that we could have that information as the commission considered it. We have a draft of that balance sheet that I can share with you today, and we're working on finalizing this for your commission meeting. Mara, can you pull up the PDF? Or I guess it's an Excel sheet, not a PDF. Oh, you cleaned it up. It looks so pretty. Can you make it a little bigger? It's really small. Thank you. So our data team went through and looked at the different policies and assessed whether it would be an increase or decrease in MAC. So the first one they looked at was reducing the caseload for first-year lawyers under the parent-child representation program down to 55. This doesn't have any effect on MAC because the parent-child representation program is not a MAC-based program. So there is no impact on MAC because that's not the metric in which we buy public defense for parent-child representation program. A similar policy for the first-year lawyers would result in a decrease of 10 MAC. So it would decrease the overall MAC capacity of first-year lawyers by 33%, and that would decrease the contracted MAC from 30 to 20. It's a 2% overall reduction in current criminal MAC, which would be 10 MAC. The co-counsel policy, we expect that this would increase MAC, but we don't have good data right now on how people are using co-counsel, because in our caseload reports, the column for saying there's co-counsel on cases is an optional column for people to use, not a mandatory one. So we have inconsistent reporting on how co-counsel is being currently used. So we expect that it would increase MAC, but we can't put a number on that. The part
I was just gonna say, is that because, I mean, you believe anecdotally that there are too many co-counsel appointments?
we think right now that co-counsel is largely being used as a tool for supervision, either on entry-level cases like misdemeanor cases, or when somebody is leveling up in a case type, they're co-counseling a trial in order to get criteria. So we think that's the majority of where co-counsel is used now, and this policy would flip it so that it would make co-counsel mandatory for some case types, murder 1, Jessica's Law, and then it would make it presumptive for other case types like murder 2, third strike sentencing. And then it would be on an as requested basis after that. And so they would need approval, and we would be able to really sort out what is the difference between co-counsel and supervision on cases, whereas now that's a bit muddied.
All right.
The partial waiting for early withdrawal. This is an area where we think there's potential to really increase the MAC capacity. And although the largest effects would be on the Measure 11 and minor felony cases. So we would see an increase of 19 MAC across the contract cycle. Partial waiting for second and subsequent attorneys. We also expect this would be an increase. We're missing an important piece of information in tracking the data right now, which is that because the policy says the 50% only applies if the case is the subsequent attorneys in the same law firm, we don't know within the consortia structure which lawyers are in the same law firm. So we know the nonprofit public defender offices, that's all one law firm. But when we look at the consortias, we know which lawyers are operating under the consortias, but we don't know if some of them are in the same firm or if they're in different firms. So that's why we don't have a number in there, although we are expecting it would be an increase, and we would need to clean up the caseload reporting on our end in order to get that information to move forward. The attorney warrant removal policy, this doesn't actually get you that much MAC. It gets you nothing unless you pair it with the partial waiting for early withdrawal of cases. But paired with the partial waiting, it's a pretty minimal impact in terms of how much MAC you would recoup. The vacancy funding, while we're not seeing a specific MAC impact, I would note that we paid for 21.8 prorated MAC that was vacant during this contract cycle. So there is a potential for significant cost savings that could then be reallocated to purchase more MAC within the contract. And then the largest area in which we would increase MAC is by through contract compliance policy. This policy still assumes a 15% variance in the contract. So if we were to enforce the policy when providers are below 85% of utilization until they reach 85% of utilization, we would see an increase of 21.54 MAC statewide. So go ahead.
What's the feedback from public defenders to these changes? What are you hearing?
The feedback that we received was provided to the commission in memorandum and in public comment. There was support for the reduced caseload program for first-year lawyers, although we heard from many that it's still too many cases and they would like to see it closer to the national caseload standard. And then on the partial waiting for early withdrawal cases, we heard some feedback that it was punishing lawyers who do a lot of work on their clients' cases and then get fired by their client kind of at the last minute. Right. And wanted to know if there could be, I heard feedback asking if there could be an exception where a lawyer could attest, like, I put in 45 hours of work on this case and received the whole credit, even if they didn't represent the client until the case closed. So there was a request for some leniency there. Generally, I would say the feedback was not positive, and folks really felt like this was a backdoor way to increase caseloads for the same or less compensation for what they're currently receiving.
I appreciate the summary.
Jesse, may I ask a question? I'm sorry, Peter, go ahead.
I appreciate the summary.
So practically, how does an attorney who's below 85%, say in a public defender's office, take on more work? I mean, I suppose that some of the boundaries why that person's under 85% may be, conflicts as to other clients in a multi-defendant case. I don't know that it's always so easy to adjust upward above 85% in a way that's consistent with ethical lawyering.
Right. So there are multiple reasons why somebody might be below 85%. And you've identified one of them. We might be over-contracted in an area, right? We might have more public defenders under contract than what we need to meet the charging in that area. So we could reduce the contract and say we actually don't need 4 lawyers, full-time lawyers under this contract. We need 3.5 full-time lawyers under this contract, and reduce the contract amount based on what's happening within the area. We could work with a lawyer who's maybe under contract to take cases hourly if there really is just a partial need for conflict counsel and a contract has us over contracted in the area. So that's certainly one reason. Could be something that we'd fix with a contract adjustment. And we do that now. We're actively engaged in those conversations with our providers. But the other reason why would be that a lawyer would file a notice with us that says, I can't ethically take more cases right now, and I'm shut off for caseload pickup. We kind of have a bit of a black box when lawyers do that at this point in time, where we don't have lawyers specifying what the nature of the ethical shut off is for. And so, I mean, that is the other reason why people are below, is that they tell us that they're ethically shut off, and then they don't take more cases until they feel that they can handle more clients. I do see Brooke very politely raising his hand too.
Yeah, go ahead, Brooke.
Howdy. Sorry, my law school class just got done. I wanted to join you guys. So I just wanted to comment on that because, I mean, obviously I'm not now a director of a public defender's office, but we would frequently have several attorneys in the office who were not taking new cases. And it was usually a combination or separately, either attorneys who were having interpersonal problems at home or at work such that we did not want to do the one more case that would break their back and have them leave the system, because that really is a concern, especially when somebody, maybe they're in recovery. There's all sorts of reasons. So that was one concern. The second was lawyers who were on improvement plans, where I would frequently talk to the presiding judge about this and say, look, I realize this person's case numbers look low if you look in the dashboard, but this is why we have them on an improvement plan. This is why I'm getting feedback from you and the other judges every 3 or 6 months about this person. And then the third one was people who were just over capacity that would really clearly show up in an open caseload model, but doesn't show up under our current model. So, for instance, someone who maybe this year they've only taken the third their MAC, even though it's 2/3 of the 11 trial, that also specific reasons you just cannot give that person any more, or they will walk out the door. And so those are the reasons. And Jesse, I know you're aware of all those reasons, but I just wanted to comment on that. And that's where something, I think it would be great if OPDC had more information, particularly if you don't have a transparent relationship with an administrator for a particular organization, a nonprofit or a consortium, because really, how are you going to know otherwise?
Right. I agree. And the way that the compliance policy is structured is that we would start off by having a conversation with the provider to notify them that they were significantly below the MAC, and then talk with them about what the basis is, and then figure out a performance plan to get them back up to MAC. And then if they aren't able to comply with that performance plan, we would be looking at reducing their contract payments to target that administrative payment, because on all of our contracts we pay 5% administrative fee. So we would be looking at reducing that administrative fee. And then also reducing the number of contracted positions if there really is a misalignment between the, if we're overstaffed in an area. I will also note that the compliance policy includes offering support in the terms of like recommending mentorship or things of that nature if there is a need to offer additional support to help bring people to a place where they can handle that caseload.
So sticking with this particular policy, I mean, I have a couple of just practical considerations that are on the administrative side. One of them is, I know that historically, there's been difficulty with having staff available on the agency side that can do the kind of monitoring that would need to be done to ensure that their contracts are in compliance. And also, if we're only having caseload reports that are due the 25th of the month following the month, then the information that we're getting is so old to be able to effectively address this that it may be problematic. And I guess the other thing that I think is that's really important is to define the time period. Because, you know, when you do those reports, it's a snapshot in time, and it might be that the next day, I'm in an extreme example, that people are above the 85%. So I think, you know, if we're going to do something like this, I certainly understand why it makes sense. There's already a contract term that we have in the contracts that say that we're going to do something like this. We just haven't enforced it. So I'm not sure we need to fix it as much as we need to actually do what's already in the contract. And a big part of that is having the adequate staff to be able to do that. And, you know, if there's going to be some cleanup, it should be about defining the time period. So, you know, if you're 85% over a certain period of time, and then most of the time, as we've already talked about, I mean, it's going to be really one of two situations where either over contracted and you're going to be talking to them about that so we can move some back around, or it's going to be, you know, ethical capacity, which really is under contracting, right? So we're under contracted if there's ethical capacity issues potentially. So that would be a different discussion to, you know, maybe we do a contract adjustment to adjust the other way, you know, to get more contractors in, or I don't know, something. But that's just kind of my thought about that particular provision.
Your points on the agency staffing are well taken. We are working on improving that by building out a procurement division. We're also recruiting right now for a compliance manager that could oversee the staff within that unit. So I do think we recognize that staffing shortage and are doing what we can to address it. We also have requests within the policy option packages that would help to get to that. One thing this contract compliance policy has that doesn't currently exist in our contracts is the ability to for the agency to keep the money if we reduce the administrative fee or withhold money from the contract. Right now, it says that we'll refund them once they come into compliance. So we hold the money back, but would eventually give it to the contractor. That's very difficult to enforce, especially with the delay that you noted on caseload reporting. But the change in the contract policy would allow the agency to retain those funds, so it would the money would not go back to the contractor.
Okay, so when you say on the spreadsheet that it would free up 21.5% or 21.54 MAC, am I off base in thinking that if we enforce the current contract policy that exists now, it would still free up the same amount of MAC or close to it? In other words, other than that one change that you're talking about, keeping the money, what do we need a policy change or contract change?
I think we need the policy change to create more clarity around what steps the agency is committing to taking and what the consequences would be. Right now, we just don't have a lot of teeth in the contract around enforcement.
And if we have a contractor that says, we're ethically shut off and we're not going to take any more cases, and they're under 85%, how would the contract terms notify a contractor of what would happen if they did that?
I would recommend that the agency better define and track why somebody would ethically shut off, because currently people just file a form with us that says I can't take any more cases, and there's no looking behind that form. It doesn't have a because I have 3 trials coming up, because I'm going on disability leave, because, it doesn't have a more specification about what the reason is why they can't take any more cases. So it's not possible for us to follow up with the contractor and say, how do we support you in getting to a place where you ethically can take more cases, or do we need to make sort of long-term changes here? So that is not encompassed in these policies before you, but I would recommend that the agency does need to create a better mechanism to evaluate those ethical shutoff notices.
I mean, I think that's really kind of the point, right, of why we're going to make policy changes is for notice. So if A happens, then then the agency will do B. And so whatever policy changes we make, I think need to be that information needs to be really clear about, this is what happens if this 85% is triggered. First, how does it get triggered? Second is, we'll define it. What does that actually mean? What's the time period? All of the things that we've kind of talked about today. I think I guess, unfortunately, where we are at with this is it needs to be very granular if we're going to do something like this. So it's very clear to everyone what the consequences are, because this is going to be a really big change. And it is going to get to the heart of the public defense crisis, with lawyers who are indicating that they are not ethically able to take cases, and most commonly district attorneys and or judges who are questioning that. And so if we're going to, insert ourselves into that more actively, I think it needs to be very clear, and the terms need to be very well defined so that we're all operating off the same page. I can't remember if it was Brooke first. I don't have the numbers on Zoom, Brooke or Peter, but just chime in.
So let Brooke can go. Brooke knows more than I do.
Go ahead, Brooke.
No, Peter knows more, almost all these things, but I'll be quick. Jennifer, I agree with you. I can't. It seems like a real morass to get into questioning why attorneys don't have ethical capacity. But if OPDC is going to do this, we need to have a way of being more specific to give the agency some better cover and give the attorneys some better cover for what they ethically need to do, and to make sure that this is all being done in good faith. I wanted to respond on one of the other things. Tell me if this is not the right time to do this, but if the agency is seriously considering the change in vacancy policy, I think there's 2 issues of vacancies. First of all, contractors would like to be paid when they're hiring people in good faith. I get that. I guess I'm kind of neutral on that because I can understand both sides of that. Where I think it makes a big deal with vacancies, though, is it is incredibly hard to hire a competent attorney within 60 days. It's almost impossible unless you already have someone in the pipeline. For offices like mine and offices like Carl's, we actually had to resort to doing standard hiring classes each year, and he still does that, and so does Lane County, where you guess the number of people and it rolls around. So the issue, I think, there isn't so much whether it might be defunded after 2 months or whether you switch it to defunded after a month or whatever. I don't really care. But the bigger issue is, will that person be able to work there once they do hire that person? So I don't quite understand where this savings of 21 FTE or 23 FTE comes in. Does it mean that that contractor doesn't get to rehire if they don't do it within 60? Or does it just mean the money is appropriated in the meantime? There's a big difference of that. And if it's the latter, I think there's going to be large unintended consequences of that.
Yeah, let's put a pin in that. I agree. And there's other issues too with paid
Okay.
leave and all kinds of stuff. And that I think that's a bigger, a big conversation that we need to have. And let's have that next. But let's stick real quickly with the contract compliance and see if we can bring that to a close. Peter?
Yeah, this is nibbling around the edges. I mean, this is not going to solve the crisis, but I do think we have to go down this road. I appreciate the work that's being done to do it. And Jennifer, I just wanted to back your comments. It's really important for us to have really clarity of what the process is, because we leave ourselves vulnerable to that. The district attorneys saying, "Hey, it's a work slowdown" or whatever the hell. We have to be able to say this is how we're approaching it. And you have to try to find that balance. I appreciate Jessica's approach to trying to find that balance by saying we're trying to squeeze every single dollar through the system to make sure we get every possible case covered, but we have to balance that with the ethical consideration. So I just want to back you on that, Jennifer, that we really have to, it's not enough just to do the policies as written here. We have to say what the process is going to be to implement the policies.
Yeah, thank you. I appreciate that. Rob? On the contract compliance piece, do you have something you want to talk about?
Rob, you're muted.
You're muted. Yeah.
Yeah, can you hear me okay now?
Yes.
I should be off now. Can you hear me okay?
Yeah.
Sorry, I'm not at home. I'm on a different network. So it's just
Now I can't hear you.
a little bit for me. No, can you hear me now?
Yeah.
No,
Yeah, maybe
forget it.
if you just turned your video off, it might help. But just talk. Okay, try
Is
that.
that better?
Yes, much.
Issue. So on the compliance, I guess on the 85%, it has been in contracts. Most people are aware of that. I agree with all of that. I do think a little bit of are occurring, whether you sort of ethical capacity, workload, or it's a personnel issue, or it's a training. And I don't know how much. Obviously, you have confidential issue, you have personnel issue. I totally get that. But I do agree with you as far as more information on the vacancy. I'm going to throw something in here on the vacancy.
Hold
I
on,
never
hold
quite
on.
understood why you got full funding. Okay.
I was just gonna say, I wanna do one at a time just because I think it'll flow easier. So put a pin on the vacancy piece and let me see if
Okay.
anybody else has any other comments about the contract compliance piece. Does anybody have anything, other comments, that we want to give, or feedback that we want to give Jessica about that?
Okay.
All right, Jessica, do you have enough information from us to be able to have direction about how to proceed on that?
Yes, I think so. It sounded like there's more information wanted regarding policy or I'm sorry, process and how the enforcement of it would actually work. That's probably more at the process level than at the policy level. So we'll see what we can do to prepare for the meeting on next week, but we may just need to make a commitment that we will publicize a process.
Okay, fair enough. All right. Okay, let's move to vacancy funding. I want to tee that up a little bit. And I had Susan and I meet weekly with Jesse, and we discussed this this week. And let me just give you kind of our just general thoughts about that, because it'll help, I think, further the discussion. So there's some concerns that have been brought up both in public comment and just, generally by providers and also by commissioners about the vacancy funding piece and whether or not that will impact contractors' legal obligations for paid leave. And if so, let's just assume yes, what is our obligation to pay for positions that are vacant if the employer, because we don't have a legal obligation to do that, but the employer does. So what do we want to do about that? And do we want to treat vacancies for protected vacancies, let's just call them protected leave, differently than vacancies for employment related, like a new hire, you have a position that's vacant because you need to hire someone, or should those positions be treated the same? So should a vacancy be a vacancy? It doesn't matter why you have a vacancy. You know, for consistency purposes, doesn't matter. And if there is a vacancy, do we make a distinction between just basically suspending payment, a portion of the payment for the actual employee, and then the provider gets that money reinstated when the person comes back? Or do we say 100% of the money is gone, and then you get it back when you hire? You know, those are kind of some of the decision points that I think that we need to talk about. And do we want to do anything at all, obviously, is one of them. But that's a summary of the discussions that we've heard from, or the comments that we've heard from public comment, and kind of the shorter discussion that Susan and I had with Jesse this week. So with that, I cut off all the people who wanted to talk about vacancy funding. So Brooke, go ahead, and you're up first. You're muted if you're talking. Okay. Well, we'll circle back to Brooke. Okay, Peter. Nothing? Okay, how about Rob?
Yeah, a couple of thoughts on that. If someone works for an entity, whether it's a law firm, well, a law firm, I guess, maybe a consortium, but for a law firm, I guess, sure. I don't understand why we would continue to pay them the full rate anyway when they're not paying the salary of the lawyer. I understand they have to keep the overhead going with the staff, so that lawyer probably. So I'm not sure why terminate upon the termination of the employment. Now, if the person goes on leave, family medical leave or whatever, some sort of an issue, they're still employed then, but they're not taking cases. Perhaps that is a 60-day or 90-day thing that you'd be willing to do as a matter of policy, good policy, to make sure they don't lose that person if they're willing to come back into the system. And that's a different scenario, I guess. And so I also think 60 days, I don't really like the idea of we pay them for 60 days and we cut them off. Because I think you should look at treating the sunk capital costs and the rents and everything you've got the law firm or the lawyer to continue to pay. And it is a law firm, because if it's just a lawyer in a consortium that's quitting, they're just not getting paid anymore, except for maybe some wind-up costs. But so for the law firm, yes, they got to pay that. I'm guessing it takes more like 3 to 4 months to get someone on board to take the case. And so I guess what I would look at doing or consider doing or recommend is taking a look at an immediate 40% or 50% reduction, because that's about the cost of the lawyer. But make it 120 days, not 60, which ends up, by the way, being the same cost, but allows that law firm to take some time and get somebody. And if it's in a situation where it's a medical leave or family leave, maybe we do a policy of doing a 60 or 90 days. And then if the lawyer stays and they're taking cases, they're great, good for us. And if they're gone, then I guess we roll into the 40 or 50% reduction at that point.
So
those are just some
current
thoughts.
policy,
it's a complicated thing.
I was just gonna say the current policy is immediate reduction to 50%, and then we fund it 50% for 60 days, and there can be an extension up to 120, right, Jesse?
No, the current policy is full payment for
Oh.
60 days, and then there can be a reduction to a prorated $72,000 a year for up to 120 days. So that's the current policy. This policy would be an immediate reduction to 50% for 60 days, and then they would maintain the position authority to rehire the position for an additional 30 days, but not beyond. I think one of the challenges that the agency faces is that sometimes we have MAC that is tied up in these vacancies. So it's been, the position authority is being held by an entity that, and somebody else is saying we could hire right now. But we don't have the ability to give them position authority until we wait for this position authority to lapse. And so sometimes that happens within a jurisdiction where you have two providers in a jurisdiction and one of them has a vacancy and the other one could hire, but you're waiting 120 days and then they can't hire again because that lawyer they were going to hire has taken a job. And sometimes it happens from one county to another county where, say, Deschutes County needs people, but all of our vacancy funding is tied up in Marion County. And so you're saying, well, as soon as this vacancy frees up, you can hire in Deschutes, but we don't have MAC to give you right now. So shortening it up would give us more flexibility to be able to move vacant positions from one entity to another or one jurisdiction to another sooner, which I think is important for the agency to be able to respond to where the need is. We also evaluate new positions based on the need in the jurisdiction. So we look at, is this an area that's understaffed or overstaffed before we give position authority to hire? So areas that have ongoing unrepresented would still be the highest priority areas for us to add MAC to. So for example, if a person left, say, Coos County, we know there's an ongoing need to hire in Coos County. And even if it was outside of the 90 days, if they were able to identify a new person to bring in, we would make that a priority for them to be able to get MAC because there's an ongoing need in that community.
I think that's very helpful. I've just, it's so hard to know I want to be very fiscally responsible and mindful of that. It's really important. It's important that we not pay for lawyers that aren't taking cases or positions where there are no lawyers taking cases. I also want to be mindful of entities, including the state trial division, that are required to provide paid leave or unpaid. Paid leave, Oregon is not paid by the employer, but it's a protected, let's just call it protected leave, to provide protected leave and not be able to subject to we've sort of back end having those people potentially sued because they no longer have position authority to bring someone back because we've taken that position authority away from them. So
yeah, I think this is one of the challenges with a contracting system, right? The state is not obligated to pay for protected leave for independent contractors. We have no statutory obligation to pay for protected leave for independent contractors. But many of our independent contractors are themselves employers who do have an obligation to pay for protected leave for their staff. And that makes it that is a very tricky piece of the way that our current public defense system is built with all of these independent contractors. And it's different for state employees because employees of the state are entitled to have paid protected leave by the state of Oregon in a way that's different from the independent contracting system. And I hear you all that 90 days may not be enough time to hire in some areas that people may have trouble recruiting. I think the state expectation is that we hire within 55 days.
So when you say that on your chart that there's no impact on MAC, that's because you would just imagine that if there were MAC available, you just move it from one place to the other. It wouldn't be, you're not adding it into the system, you're reallocating it, right?
Right.
Okay.
And I think there would be cost savings for the program. The other thing that we've heard significantly about this from both sides, from both pro and con, is that the way in which modern recruiting works for lawyers is that third-year law students apply for positions in the fall of their third year, or yeah, in the fall of their third year that would start the following fall once they're barred. And so large law firms are hiring classes of lawyers, and they may be using our current vacancy policy, which allows them to hold positions for up to 120 days in order to save spots to bring in a class of lawyers that all get trained up together. And I can see from the law firm's perspective why that's a very important recruiting and training tool. I will also say that we have heard the downside of that, where it's like there's current crisis right now. There's somebody they could potentially bring in now, but they're not filling the position and they're holding it to bring in a class of lawyers later. So I think we need to create a mechanism different from the vacancy policy that allows for that recruitment process to happen, but doesn't encourage people to wait on hiring decisions.
Yeah, I mean, because the practical effect of that too is that the money is being collected and not paid out.
Mm-hmm.
So, which is, yeah, so, which has an impact on MAC. I mean, that, you know, it has an impact on the ability to take cases. Okay, well, any other thoughts about that? Okay. All right, let's just kind of start. Any comments, any concerns, discussion about reducing the caseload for first-year attorneys? We've talked about that before, about people generally think that's a good idea. Anybody want to chime in? Okay, doesn't look like it. What about co-counsel policy? Any questions, any feedback about that? Any concerns? I think it makes sense to have an actual policy about that because we don't have one now. I would say to build in flexibility both on the needing co-counsel, because maybe you actually don't need co-counsel on a case where you think you might. And also, if you have an unusual situation on a case where you wouldn't ordinarily have co-counsel, the flexibility to make a case for that on a case-by-case basis if there's some special circumstances that might. I mean, I can think of a situation right now that just popped into my head where there was a case that I was involved with many, many years ago that wasn't a case where you would necessarily consider that co-counsel would be necessary, but this person was a veteran and had moved around a lot, that the defendant was a veteran and had moved around a lot. And there were records everywhere, all over the world for this person. And we got a lawyer in who was an expert on collecting military records, who literally went with an investigator all over the world and did interviews and also collected all of these records. So that's a weird case, right? But that is a situation where you might need co-counsel because they have a special unique skill set for that case. So I'd say just, you know, make sure that there's some ability to ask in unique situations. But I think it makes sense to have a policy about that for sure. Okay, let's talk about partial waiting for early withdrawal. One of the questions I have about this that I've thought about in the last few weeks is, would it make sense to have a time period? So instead of early withdrawal, define what early withdrawal really means, and can you capture most of this MAC by defining it, within 30 days or something, or, something on the front end. Because you talked about a situation where, there's been feedback about, well, if the client hires you and you've done all this work and you're almost done with the case, I wouldn't really consider that to be an early withdrawal. That So I mean, I guess that's my point is, can we define it in a way where we're really talking about what we're talking about, which is if you discover you have a conflict after being on the case for 3 weeks, you don't get credit for that case, or you don't get full credit for that case, as opposed to somebody who's been on the case for 9 months and the client, when they have to make a decision about whether or not to go to trial, fires you.
And we did do it in terms of a time frame. So we set 0, 50, 75, and 90% credit based on the time frame that you'd been on the case, and also based on the crime seriousness. So this, because of the time to disposition on certain case types. So we did set it up in terms of a time frame. I think, in an ideal world, we would do it actually based on more of a workload model, like
Right.
having filed motions on a case, having done but we don't have the infrastructure to track that stuff right now. So I think the best we can do is how long you're on the case.
Right, fair enough. I remember that when you said that there was that chart. I apologize. Susan.
Oh, you're muted, Susan.
Yeah, sorry about that. When I was reading through the summary that you provided, Jesse, at the last commission meeting, one of the things that caught my eye was actually under the credit for subsequent attorneys comments, but in a way, the early withdrawal, partial waiting, credit for subsequent attorneys, that's all sort of tied together at some level. And one of the suggestions that was made was to credit, to somehow be able to credit the time actually spent on the case or the actual work performed on the case. And I understand that we don't have the infrastructure to ask people to submit, to keep track of their time and submit it in a way that would let us track it with actual real data. But is there a way to have attorneys to be able to report on their estimated time that they put in on a case and combine that with some description of how they've spent that time? I realize this would mean trusting the lawyers to be honest and accurate to the extent that they could. Some lawyers actually do keep track of their time. Not everybody who's a defense attorney does. But if there was a way to combine that with the timeframes so that people who felt that the time frame wasn't accurately capturing the amount of actual work or the type of actual work that they had done, could at least give that information and request some modification of the policy for their specific case. Would there be a way to do that? Because if there was a way to do that, I think it might go a little farther in limiting some of the hostility that I sense from providers toward these policies.
Brooke?
I would agree with that. I have to say that I'm of two minds about this policy. At one level, I actually think it's highly inappropriate to ever give credit to a law firm or attorney when a conflict existed on the case from the very get-go. And what I mean by that is it's not uncommon, despite everyone's best good faith efforts, that you get appointed a case and you tell the court you can't take that case, and the court's already given you that appointment. And those cases showed up quite often be with, despite everyone's best efforts in Lane County, you know, the court would say, here you go. We'd say, hey, we told you we can't take that case. You're like, oops, okay. Under the current system, I think that's worth a quarter credit or whatever. I always felt pretty embarrassed that we got anything for that because I never thought we should. So if there's a conflict from the get-go, even if it takes a week to spot it, I think it's entirely inappropriate for the law firm to get any work on it. But then on the other hand, if you put in a ton of work and you don't realize until you know, your 200th page of discovery when a witness name came up that's a conflict and you didn't see it, I really think you should get credit. And I think we actually already have infrastructure to solve this problem because there's already the extraordinary case credit model that OPDC uses when a contractor can say, hey, I need extra MAC credit for this case because I did X, Y, and Z. So I wonder if there would be a way on that initial withdrawal, when someone is withdrawing in the first, I don't know, 7 to 30 days, I don't care about the number, but when they're doing that initial withdrawal, the presumption maybe is they get nothing unless they fill out an extraordinary case credit where they have to fill out an affidavit that just says, this is what I did. I don't care if it's an affidavit. And I know that's more problematic for contractors that don't keep time. Now that they keep time, I can't imagine not keeping time, but I realize it's a world of difference. And I realize half my office would have quit if I'd made them keep time. So I'm not saying we keep time to do it, but I don't think it's that big of a deal to have a contractor fill out an extraordinary case credit if they're asking for credit on an initial withdrawal period. But I think that ends after a couple of weeks. And beyond that, when you discover a conflict, if you've already put in work, I think the presumption should be you get credit. So I guess I'm of two minds depending on how far in you are, but I do agree it needs some revisions.
Okay. I don't know. I will talk to our team about what we really have to do that could make it. I think the answer is going to be very little. It would be ad hoc. It would be hard to do it in a consistent, uniform way. But I will look into it. And I see Rob echoed in the chat some of the comments of other commissioners saying that partial credit for early withdrawal, you should differentiate between in and out of custody, and partial credit based on work performed for attorneys who do contemporaneous timekeeping. So I can ask the team what mechanisms we might be able to use to improve upon this policy. And I also suspect at the end of the day, we're likely to be told at this point in time, all we can really do is keep time, but we could work with OJD to create a data-driven task to perform analysis in the future. And it would probably be some time out before we could implement anything like that.
Susan? You're muted.
You'd think I'd learn, right? Brooke was talking about conflicts that come up early. I'm not sure how it would relate to conflicts that come up later because of problems with a particular client. But the other thing I wanted to ask was, and I'm asking for information, is there ever a situation where a lawyer under this policy would get full credit because the lawyer was on the case for a really long time, but that would be a kind of a windfall because for one reason or another, the lawyer hadn't done an amount of work that amount of time might suggest? Is that ever an issue?
Under the way that the policy is currently written, it's just looking at how much time, how many days the case was open for, and makes no assessment about how much work was done on the case. So certainly there could be a lawyer who has a whole bunch of performance issues and isn't doing a whole lot of work on their case, and it wouldn't impact how much credit they got on it.
So I think that if that's true, and that's combined with not allowing lawyers for whom the case has not been open that long, but who do a lot of work, not allowing those lawyers who do a lot of work in a shorter period of time to be able to ask for um, more remuneration, similar to what Brooke was suggesting. The distinction between the windfall and the lack of getting enough, I think, exacerbates some of the hostility that's felt about this policy. So if there's no way to um, undo the windfall situation, I think it's really important to find some way to correct for the lack of sufficient credit situation.
I actually really like Brooke's idea and concepts about pairing the current system with changes. And that is, if you make the presumption that you get no credit for early withdrawal or whatever the proposal is, including and also with the second and subsequent attorney too, because that's a very different situation. Sometimes you step in and just the fact that there's a new lawyer immediately resolves the case, or you have to try the case and you're doing everything. You're basically, you might as well have come in on day one. So it doesn't really seem fair under those circumstances to only get partial credit, and it doesn't seem fair if you resolve the case in 10 minutes to get a lot of credit. So I think if you kind of combine that with the presumption is X, and you can ask us for an exception. That makes a lot of sense, because if somebody says you have no idea how much time I spent on this case, and they'll know, even if they're not timekeeping, they're going to write you a letter that tells you every single thing they did on that case so that they can get credit for it. Either, the consortium administrator or the boss or whoever, but that lawyer can ask for additional credit. I think that solves the problem that we're trying to solve with the policy, which we can't solve unless we're timekeeping. Susan?
So Jennifer, am I hearing keep the policy for partial waiting, but create an exception?
I think that's what generally people are saying, is that, you can make the policy for partial waiting and allow an exception for that. Is that what people are,
I think so. And I think, in an ideal world, we would have a workload model, but we're not allowed to have that right now, evidently. So I think that allowing for an exception would be a step toward something that allows people to actually get credit for what they do. And, in terms of being able to have staff who can deal with these requests for exceptions, my understanding is that for lawyers who are working on an hourly basis right now, if they turn in a request for payment where the number of hours they say they have worked doesn't fit with, for example, how long the case was open, you couldn't possibly put in that many hours given the amount of time the case was open, or if the amount of hours they're asking for doesn't seem to fit with the way the case was resolved. My understanding is our staff currently screens for that kind of thing. So it's something similar to what they would be doing to evaluate whether the exception requests were valid.
Well, it seems like there's an administrator that does that. Whether it's a contract administrator or, we could have it so that the exceptions have to come through the administrator, and the administrator has to do the first, examination of that.
You could certainly do it that way. And so again, I think that we really need to do everything we can do to make this work for our providers. So I would like to see us try harder to do that.
Yeah, I think that is a really good point. I was thinking that when you were talking, Susan, that this seems to strike a balance between, us being responsible and trying to recoup some of the some MAC, but also really listens to what providers are saying, which is, most providers are going to agree, as Brooks talked about, if I don't I get off the case immediately, I shouldn't get credit for it. But hey, if I do a bunch of work on this case, then I should be able to get credit for the work that I do. And I think that that really is responsive to the feedback that we've been getting from providers. Does anybody have any other comments about that? We're winding down with time, but also I think we're near the end of the policies too, so I want to make sure we cover all of them. Are there any other comments about the partial weighting provisions? Okay. So the warrant removal policy, we currently have 180-day removal. 180
Correct.
removal, and this would change it to 90, which really, I think OJD data shows there's not going to be a significant amount of MAC that's recouped between, and look at your kitty, significant amount of MAC that'll be recouped between 180 and 90 because most of the people come back in that 100 in the 90, or they don't come back in the 180. So
Right. Yeah. The big curve is in the first 90, and then after that, it drops off pretty significantly. But we also don't get a ton of MAC back by making this change. It's a pretty small variance.
any thoughts about that, or comments or feedback? Okay, doesn't look like it. Okay, so 6:25. Anybody want to make any other comments about these policies that we haven't already covered that's important for the agency to hear?
I will just note for you all that our team is getting together at 9 o'clock in the morning to review the comments the commissioners have provided to us today and work on incorporating them into the policies. And then we are planning to publish them tomorrow afternoon for your commission meeting. So it's going to be pretty fast turnaround time. And please give us a little bit of grace for typos and that kind of stuff. If we, with that fast turnaround time, it's not as polished as we would want it to be.
Well, we very much appreciate it and appreciate all of your hard work in trying to, as Peter says, nip around the edges, but still make some, try to make some changes so that we can move this forward. Rob?
Hey, so I just want to thank you, Jesse, and the team here as well. This is not a small deal we just did if we implement this. This is 31.72 potential MAC, give or take some unknowns here. That is almost as many new MAC lawyers as our plan proposes to add every year. So this is not a little thing. And I think this is really shows the taxpayer and the legislature that we're working really hard to solve this problem. And we are taking responsibility, and the lawyers are taking responsibility. And I want to congratulate you. And I support this. I was really good to be able to see the plus minus on this. I think this is really, it's even better than I expected. So thank you.
And it's, I 100% agree. And I think it's probably even more than 31.72 because we don't have the numbers on co-counsel. And I suspect that that's pretty significant. That's a pretty big number. And so, yes, a lot of hard work. This is really, I think that, you know, if we implement these policies, putting together a chart like this, tracking the data very closely and making sure that we have a chart like this to talk about this is what we're doing to help solve this problem is really important for messaging too, so that people know what we're doing.
Yeah, without adding a single additional taxpayer dollar.
Yeah, yeah. Revenue neutral within budgetary constraints. All those wonderful things that we're hearing lately. All right, and with that, thank you everybody for your time. Really appreciate it. And we will see you either on video or in person in Medford on Wednesday.
Great.
Yay.
Maybe if you come down on Tuesday,
Oh,
come
Tuesday,
to the
right.
too. Yeah. All
Yeah.
right. Thank you.
All right, thank you.
Bye.